Did you know that if you experience sexual harassment or sex discrimination in the workplace, you can take your employer to court and have your case heard by a jury, even if you signed a legally binding arbitration agreement? This week, the courts found something even crazier. Even if you agree to arbitration, go through arbitration, but during the course and scope of arbitration, facts come out that show that your employer's actions were actually motivated by your sex, you can actually pull your case from arbitration back into court and have it heard by a jury. Meet Dr. Ding Ding. That really is her name. She was the CFO of this pharmaceutical company. She was terminated. She brought claims against the employer, claiming racial discrimination, discrimination on the basis of her national origin, claimed that she was discriminated against because she was a victim of domestic violence. She had signed a legally binding arbitration agreement and the employer pulled her into arbitration. She agreed and they went through arbitration for a year. Well, during the course and scope of discovery, facts came out that made it pretty clear that some of the employer's actions were because of her gender. For example, the CEO sent out an email before she was hired giving his idea of the ideal phenotype for the CFO. And guess what? All of the qualities he named were actually of males. Well, clearly he didn't want a woman there. In addition, she claimed that she was sidelined, taken off projects, and during discovery, it came out that some of this was motivated by clients complaining that she was too aggressive for a woman. Her attorney took a step back and was like, whoa, these are new facts. This is new information we couldn't have known. Now there are gender discrimination claims. If we had known this, we would have never agreed to arbitration. We want to have this heard by a jury. The employer was like, well, you already agreed to arbitration. We've been here a year. I've paid for this. You're staying. The court actually agreed with Dr. Ding Ding. The court said that it's not like she's trying to bring new claims of things she already knew about. These are brand new facts that came out during the course and scope of arbitration. She could not have known about them but for the arbitration, and she has a right to have her case heard by a jury. This is why this statute was enacted, so that people who experience sexual harassment or gender discrimination in the workplace don't have to be silenced through confidential arbitration. So they let her take her case out of arbitration and go to civil court. California employees, you are not necessarily bound to arbitration, even if you're already in it. I'm Mila, I'm an employment attorney. Follow me to know all of the new legal updates that come out as we get them. Know your rights and protect yourself at all times.